Orange County has become the first major county in California to adopt what's known as Laura's Law. Supervisors voted unanimously for it. That means people suffering from mental illness who are a threat to the community can be forced into treatment by a court. The new law comes after Kelly Thomas, a homeless mentally ill man, was killed 3 years ago by Fullerton police officers. But Laura's Law has been around for a dozen years. California state lawmakers approved it, but it's up to counties to fund it. And until yesterday, only one had, the small Nevada county near Lake Tahoe. So will Orange County lead the way for the rest of the state to adopt the law? And how effective are these kinds of laws in helping the severely mentally ill? We're going to ask these questions and more to Jeffrey Swanson. He's a professor of psychiatry and behavioral sciences at Duke University School of Medicine. He studies these types of laws around the country. Welcome.
Thank you. It's good to be with you.
Well, it's nice to have you. Laura's Law was based on New York's Kendra's Law, which has been around for a long time. How similar are they?
The legal features of Kendra's Law and Laura's Law are almost identical. That is to say, they're a form of outpatient commitment where the state's authority to involuntarily commit people is extended into the community. So it's a form of mandated community treatment. And it's a preventive form, which is to say that this can be authorized for people who don't already meet criteria for involuntary hospitalization, but it's expected based on their history that they might deteriorate in the future without treatment, and without the supervision of this court order, they might not get that treatment. So 10 states have that particular form of outpatient commitment. 45 states have some form of outpatient commitment, such as conditional release or an alternative to hospitalization on the front end. That's to say the legal part, but the part about it that is the treatment program and how that's organized and financed, that's quite different, as you've implied.
Right, right. Well, tell us, who would qualify for this court-ordered treatment?
Well, it's designed for people who have a serious mental disorder, such as schizophrenia, that impairs their ability to reason and to function in the community, who have a history of multiple hospitalizations or perhaps arrests that are connected to the fact that they don't get treatment, and don't, for whatever reason, adhere to or comply with recommended psychiatric treatment. But they have to be able to be capable of surviving safely in the community with supports. But they have a current mental status that really limits their ability to voluntarily participate in treatment, and there's a need to prevent treatment to prevent deterioration. So they're basically not just everybody who's mentally ill, and not even people who have serious mental illnesses, but it's really designed for people who have this history of sort of revolving door hospitalizations, followed by a period where they don't participate in treatment, then a deterioration, and then in the aftermath of deinstitutionalization, there were people who had this pattern. This was designed as a way to try to help people like that get treatment.
Well, how do you force someone to take medication when they just don't want to, or they don't think they need to take it?
Well, it's important to clarify that outpatient commitment laws don't actually allow forcible medication in the outpatient setting, with maybe one exception. But in general, really what happens is that there's a kind of the leverage or the sanction, or what can happen if people don't follow the treatment plan, is that they can be picked up by law enforcement, transported to a treatment facility, and hopefully persuaded to stay in treatment and to take medicine, but and they're evaluated to see whether they would meet criteria for inpatient commitment. So if you think about it, there are two components here. There's the court order and there's the treatment plan. So it's kind of a treatment plan for intensive treatment, such as case management and treatment with medication, wrapped in a court order or a legal vessel, the treatment plan inside. And the idea is it sort of commits the system to the person, as well as using the moral authority of the court to say to this person, you need to participate in treatment. But push comes to shove, if people actually say, I don't want medicine, and they don't meet the strict involuntary commitment criteria to be put in the hospital, then it can't be forced.
Mm-hmm. And that involuntary commitment criteria involves being a threat to oneself or others?
Basically, yes, a danger to self or others, or in need of treatment, of protection, shall we say. So there's the doctrine of basically the police powers of the state to protect people, and then there's the idea of parens patriae, or the state acting as a parent to take care of people who can't take care of themselves. But other than that, people have the right to refuse treatment, to be free in the community, and we live in a society that respects the rights of people to do lots of things that aren't necessarily in their best interest.
Yeah. Well, I guess that's the problem in many of these cases. I mean, how would this change a case like Kelly Thomas's case, where you have a man who is severely mentally ill, who's homeless, who's not on his medication, and who has engaged in some violent confrontations? And would this kind of law significantly help him get treatment?
Well, it could. One of the things that happens typically with it's called assisted outpatient treatment, which is kind of a euphemism, but AOT for short, is that a person will have a court-approved treatment plan that often involves being put on a team, assertive community treatment, where there's a team of people who kind of wrap the services around the person and do things like make home visits and help them to take their medication. There's a doctor on the team, but there's a lot of it that really is about the case management and to try to provide outreach to people, and that's important to have those services. So if you think about it, I mean, psychiatric treatment and things like medication for mental illness, they're not designed to solve everybody's problems in life. But if those problems and the inability to do very well and lead a normal life in the community are really related to untreated psychopathology, and the person can get treatment and also have the support around that individual to help them, then they might improve. And things like being homeless, that can be addressed directly, because housing and helping someone to get housing, perhaps to get into a subsidized housing unit, can be part of what AOT does.
And so, as I said earlier, Kendra's Law has been on the books for a while now. Has it been a success in New York?
Well, arguably it has been a great success for the people who have received it, if you look at it from the point of view of what they were like before they participated in the treatment program and the court-mandated program, and after. So if you look at it that way, and we did this evaluation in New York City, there's evidence that people had fewer hospitalizations, and they were more likely to receive the treatment and take medicine, and those things are connected to a number of good outcomes. It didn't affect a whole lot of people, because not that many people actually meet the criteria and get put on the program. And the other thing I should say about New York is that one has to think about the services that were made available. And one direct or indirect result of Kendra's Law in New York was that it enhanced the capacity of the state to provide things like assertive community treatment. There are more of those slots made available because of a big appropriation of quite a lot of money initially to do that. And I think that's very important. If you think about AOT, something like Laura's Law or Kendra's Law, as just a solution all by itself that's going to magically solve the problems of a public behavioral health care system that is fragmented and under-resourced and overburdened and doesn't work very well for people, that's probably a delusion in itself. It's like saying, here's somebody in a wheelchair at the bottom of a staircase, and we're going to pass a law to make you get up the stairs, but we don't give you a ramp. And the ramp, corresponds to treatment barriers that people have who suffer from schizophrenia and other illnesses. And so it has to be both of those things.
Yeah. I mean, I hear from people, friends of mine who have seriously mentally ill relatives, and they're very frustrated with the laws as they are right now, because they can't force their loved one to take medication unless they've committed some horrible act or are about to commit a horrible act. And I guess this doesn't necessarily address that on the face of it, but hopefully with the wraparound services it might help.
Well, yes. I mean, you can point to the to the civil commitment laws that require criteria such as dangerousness and say that that threshold is too low and it goes too far in protecting the rights of individuals who don't really know that they need treatment. On the other hand, part of this really has to do with access, as I say, and the critics of outpatient commitment say, well, if this is about access, then go ahead and solve that problem. Invest in the system, do what we know how to do, provide evidence-based treatment and outreach to people. You don't need a court order to do that. That's their argument. So it is controversial, and basically it devolves to this collision between respect for the rights of people to be free to make their own decisions about medical treatment and the social responsibility that we feel to take care of people who can't take care of themselves. And so the proponents of outpatient commitment and things like Laura's Law will say, we wouldn't let our elders with Alzheimer's disease wander around in the street, with no help. That would be inhumane. Why do we say that it's okay to do that with young adults with schizophrenia? And the other side, they say, well, wait, I'm an adult. Yes, I have an illness. I'm doing the best I can to manage it. That's up to me. I'm not, right now, imminently dangerous. I'm not criminally accused, and I'm not legally incompetent. So, on what basis does the state override my right to refuse treatment and force me into treatment? And so, those two arguments kind of pass in the night. As the reality, most people who are put on these orders in New York and elsewhere start in the hospital and actually move from a more restrictive to a less restrictive alternative.
Jeffrey Swanson, professor of psychiatry and behavioral sciences at Duke University School of Medicine. Thank you very much.
Thank you for having me.